because we're in cricket land. We'll be Nicole first. I'm batting in the middle order, and Christina's our fast bowler, so she's batting third today, and we'll go in that order. And as I said, Nicole needs to leave after her session, so please excuse her then.
Perfect.
Okay, are we ready to go?
Yes, we are live.
Are we live, Ajay?
Yes, ma'am. Yes, ma'am. We are live.
Yes. Okay, we're ready to go.
Perfect.
Terrific. Take it away, Nicole.
Fantastic. Okay, so thank you very much for inviting us to speak today. I'm delighted to be here with Dr. Allen and Professor Pinto to talk about an interesting and pertinent issue that has really plagued legislators and administrators for many years. So the challenge of articulating an optimal global standard for defining corporate residency for tax purposes is notoriously difficult, especially when you have consideration or give consideration to the competing theories that underpin corporate taxation. Despite the difficulties, it is key that we explore this issue when we consider it against the backdrop of an unprecedented and intensifying examination of the taxing rights of corporates by the global community, and in particular, the base erosion and profit shifting project. Accordingly, today our presentation will consider an optimal basis for attributing residency to corporations as a tiebreaker rule or international standard, and will advocate the revival or restoration of the effective management test as a tiebreaker rule in double tax agreements. Next slide, please. So the structure of our presentation will be as follows. So firstly, I'll consider the background to this issue, and I'll introduce the importance of the concept of corporate residence. Next, I'll move on to what is very much the focal point of our research in this area. And so what I'll discuss here is what we are focusing on and what perspectives or aspects of this issue we are not addressing in our research. I'll then hand over to Professor Pinto, who will be discussing the competing theories in relation to corporate residency in both domestic and international tax contexts. And then Professor Pinto will look at this concept of corporate residence in model tax conventions. Professor Pinto will then hand over to Dr. Allen, who will discuss the considerations of formulating a global standard and will draw upon our research conclusions in this area. Thank you. So we thought we'd begin with two apt statements by McIntyre and Cousin, which really highlight the difficulties that are associated with attributing an optimal global standard for corporate residency. The issue, as I've noted, of what is a corporation and how it should be defined is controversial. And these quotes, we think, really encapsulate the nature of these difficulties by opining the true conceptual basis for defining the residency of a corporation. So you can see on the slides, we've got the quote by McIntyre that a corporation is whatever the law says it is. Likewise, Cousin says corporations don't actually reside anywhere and their vital signs are commercial, not physiological. Thus, the indicia of residence becomes additional fodder in the battle amongst taxing jurisdictions to attract the allocation of business profits. Indeed, as we're all aware, corporations are creatures of statute, and in many ways, the law treats a corporation akin to a natural person. They're a discrete taxpayer, they can enter contracts or own property for commercial and financial undertakings. Yet on the other hand, sometimes paradoxically, the law can view the corporation as a mere conduit, attributing responsibility to the directors or owners for any wrongdoing. However, in any jurisdiction where corporate income tax is justified, this concept of residence remains key. Next slide, please. Thank you. So similarly, corporate tax policies are diverse. And as Professor Pinto will discuss next on in the presentation, no single theory has primacy. In fact, as Professor Pinto will point out, there are multiple valid tests and none of these are given explicit primacy, which causes confusion and difficulty in trying to seek and find or achieve coherent corporate tax rules. Arguably, because of this lack or this confusion, the fundamental concept of corporate residence lacks a clear policy basis. Although many countries, including Australia, US, Canada, UK, have adopted a residence-based corporate income tax system under which residents are liable to tax on their worldwide income. And notwithstanding these difficulties surrounding the concept of corporate residence, it remains incredibly important in both domestic and international contexts. In domestic context, corporation or corporate residence provides a basis for allowing and legitimising the government to exercise its rights to tax the worldwide income of companies, including the taxation of CFCs, controlled foreign corporations. It can also determine, for example, the availability of local tax incentives and concessions. In an international tax context, most, if not all, residence-based corporate tax systems operate in a hybrid form, where the tax base excludes any profit derived from foreign sources or relief is provided, like foreign income tax offsets or credits, for the amount of any tax paid or payable in foreign countries in which profits are derived. Additionally, and importantly, corporate residence dictates the application of tax treaties. Furthermore, as I mentioned in the beginning, there has been an unprecedented and intensifying examination of the taxing rights of corporates, as we'll again look at in the next few slides, in particular, the BEPS project. We will argue that when one is viewing the outcomes of this project, corporate residence remains pertinent. So when one looks at the history of corporate residence, the coordinated efforts to codify national tax rules has continued steadily since the 1920s, when the League of Nations began to standardise terms used in tax treaties. Initially, corporate residence was defined as the state in which the real centre of management resided, or the state under the laws of which that corporation were constituted. This was revised to be determined under the laws of each state, with the place of effective management becoming a tiebreaker for more than half a century. However, in 2017, the OECD withdrew the tiebreaker rule place of effective management, only including it as a consideration on which dual residency could be resolved. This withdrawal was stated to be due to the benefits that could result from being classified as a dual resident. The UN followed suit in the same year, releasing its model tax convention with no set definition of corporate residence. This development, we think, and have commented in the paper, was surprising considering the launch by the OECD of the extensive base erosion and profit shifting project. 8 or I think 9 years on now, this project is in its second phase, involving 140 countries under the inclusive framework to consider and formulate consensus-based taxing rights. Whilst no agreed meaning of corporate residence has been achieved, it is indeed timely and key to consider and revisit the tiebreaker rule used to determine corporate residence, because many of the aspects of this project relate to jurisdictional basis to tax corporates. The fact that no consensus can be reached in relation to the policy that underpins corporate residence makes it really important to understand and establish a workable tiebreaker rule. Move to the next slide. Thank you. So despite the advent of double tax agreements, the importance of corporate residence remains key. In fact, we argue that VTAs or bilateral treaties don't diminish this. There are over 3,000 tax treaties currently in force worldwide, built on and referring to residence. And for example, residency continues to determine the application of permanent establishment rules, dividends, interests, and royalties arguments. In fact, arguably, the importance of corporate residence will increase because of the BEPS project. For example, many of the proposals under Pillar 1 and 2 give way to countries of source and residence first. Therefore, by increasing the scope of corporate residence under national law, countries can take their share first before the new taxing rights come into effect in the absence of any coherent corporate residence definition. We could move to the next slide, please. Thank you. So that leads us to what is the focal point of our work or our paper in this area, which seeks an optimal corporate residency basis for attributing residency as an international standard or tiebreaker rule. It's really important to note that the focus of our research and our presentation today will contain limited practical examples. The article in our research proceeds on the important is to focus on the foundational issue of providing a robust conceptual framework. We also don't, importantly, enter into the issue or question of whether corporations should be taxed at all. We acknowledge in our work and in the presentation that many commentators argue that attributing residence to corporations is somewhat arbitrary in that they are intermediaries distributing wealth to people, so they enjoy the wealth resulting from the activities of that corporation. And we acknowledge that where it is asserted that corporate income tax is not justified and should subsequently be abolished, then there is no need or no need to define corporate residence. However, we've set that issue aside as a separate policy question beyond the scope of our research in this area, because at the present time, as I've discussed, corporate residency remains a really important key factor in asserting a jurisdiction's right to impose tax. So our paper and our presentation today considers that optimal basis for attributing residency to corporations as a tiebreaker rule or international standard. And to do this, we talk about the background and competing theories in relation to corporate residency in both domestic and international contexts. Slide, please. So I won't go through this in too much detail, but our paper reflects the structure of our presentation today, introducing the issue, providing some background, putting forward the tax theories and residence tests that are going to be taught by Professor Pinto, looking at the definition of corporate residence with consideration of the historic development in model tax conventions. We then advocate for the revival of the effective management test as a tiebreaker rule, and finally conclude. So in terms of the focal point of our thesis, and Dr. Allen will go through these points in more detail, we argue that the place of effective management remains fit for purpose on a view that strategic and high-level managerial activities provide the requisite economic nexus to establish taxing rights. We also argue that the lack of a standard tiebreaker rule for corporate residence is going to exacerbate or is expected to exacerbate international tax contexts at a conceptual level. And therefore, we advocate reviving or restoring the place of effective management as a tiebreaker rule for corporate residence. In fact, we argue that the removal of this test is not compelling and is in some ways difficult to justify considering the ongoing efforts to codify the international tax rules by the OECD. In a similar line of argument, we argue that there are inefficiencies in the mutual agreement procedure as a mechanism for resolving dual residency disputes. In particular, it can be time-consuming and expensive, and it can exacerbate any power imbalances that exist between the parties that are part of that procedure. Lastly, we look at the fact that when dual residency arises, a legislative a model based on the place of effective management should be restored and supplemented by a second order hierarchical order of residency tests to address the totality of the circumstances. And Dr. Allen will talk through the nature of those second order tests. And Dr. Allen will also argue that there are many reasons why this should be restored or revived, including universal application, adaptability, and the ability to be used in a less artificial manner when considered in the context of corporate emergence. So, an important part of coming to these focal points or these arguments as part of our research was first looking at some of the tax theories that underpin corporate residence. And to discuss this, I will hand over to Professor Pinto.
Fantastic. Thanks, Nicole, for that wonderful background and context. And I'm going to try and multitask and drive and speak at the same time. And also, I hope I don't give you a headache with the turgid part of the paper dealing with the tax theories. But some of the things Nicole has elegantly summarized, so I'll be able to pick up some time to give Christina sufficient time at the end with the crunch of what we are actually arguing. So as Nicole said, what we're going to do in the next few minutes is just briefly touch on the tax theories and then move to examine some of the corporate tests that can be derived from those theories. So if you can keep those 4 tiles in mind when we get to the tests. I'll start first with the theories, and really the starting point of our paper begins with looking at the faculty theory, which of course underpins income tax, where under this formulation, income is conceptualized as a tax that encompasses a broad range of economic gains. So all of us would be familiar. This corresponds with the notion relating back to the Haig-Simons formula, under which consumption plus any change in value between the start and end of an assessment period means effectively that income tax falls on natural persons. Now that becomes problematic where you deal with an artificial construct like a corporation, because obviously as artificial persons, corporations don't live, eat, drink, clothe, and enjoy wealth in any like manner to natural persons. So if we move from that test to try and overcome that difficulty, other commentators in the literature go to the transaction principle to base taxation on benefits that corporations receive from the state. Now, this is also not without contention, because proportionality of taxes borne by corporations relative to the benefits they receive are difficult to align and correspond. And also the proposition to tax by reason of benefits received doesn't really support a worldwide income tax system under which we operate. So from there, we go in the paper to mention that some other commentators have articulated a new basis to tax corporations, which posits that while managers are not elected by members of society, they nevertheless have significant influence on society through, for example, staffing, use of public resources, and participating and interacting in markets. And on this basis, corporate tax regulates some of this power by taxing part of the wealth in those corporations. Now, there's a lot more detail behind all of that, and we haven't got time to go into it today, but we've just given you a flavor to basically illustrate the point that, you know, if one theory can claim superiority, then we've got our answer. The corporate test should be deduced and fall out of that theory, which can then be adopted. But as we'll see, and as we've already indicated and Nicole mentioned at the start, our argument is the analysis of these tests that I'm about to go through shows a contrary result. Each theory delivers, rather than one answer, multiple answers, multiple possibilities of defining corporate residence, and therefore there's no real single test that you can say is paramount or superior. So I'm just going to briefly run through the 4 tests there on the slide you can see, starting with the faculty principle for shareholder tax in the upper left. So you'd be familiar with this, is also commonly referred to as the ability to pay principle, and again holds the tax burden is borne by natural persons. So if you take this view of the world, then it views corporate tax as a tax on the shareholders, being the natural persons. And the operative consequence of that is that corporate tax operates as an anti-deferral device of shareholders' income tax. Why? Because it means that domestic individuals will be taxed when a corporation derives its profit, whereas the profit attributable to foreign shareholders would not form part of the domestic tax system. Instead, foreign corporate profits attributable to domestic shareholders would only be taxable as they are derived, whereas the same profits derived by foreign shareholders would obviously be outside the reach of the domestic income tax jurisdiction. So it's easy, just by that simple example, to conceive how scenarios like that can become administratively troublesome. You only have to contemplate a multinational corporation with a wide shareholder base, which is common. Pursuant to this theory, the corporation would need to ascertain the tax residence status of each shareholder, which may change, may span several jurisdictions, or require a determination and arbitration in cases of dual, or indeed multiple, as we're seeing in the digital world, multiple tax residences. So if we move from there along to the separate person tax under the faculty principle. So here it's analogizes corporations to natural persons on the basis they can have or exercise personal rights to carry out commercial or financial undertakings, such as the things Nicole mentioned, entering contracts, owning property, and so forth. Now, under this modified version of the faculty theory, there are several ways of defining corporate residence. One is the origin stamped by law may be considered like the nationality of a natural person. So a corporation could be recognized as a person by incorporation or where its statutory seat resides. Alternately, it might be the address of its registered office. But as we know, where registered office is considered like a registered address of a natural person, it's highly artificial because a person may simply give the address of a friend or a relative or simply a mailing address for convenience. So it's hardly correct in an ordinary sense or even a conceptual sense to argue a person lives in the location to which their mail may be delivered. And similarly, it's not uncommon that the registered office of a corporation could be, their lawyer's address or their accountant's address, or could be subject to further challenges, including easy manipulation through the digital economy. So as a company's illegal invention, it is ultimately directed by people who make high-level decisions. Accordingly, the place where those decisions are made may direct the way in which a corporation operates and could ultimately be therefore considered as its ultimate place of residence. And that obviously leans towards the place of effective management that we are advocating for. So while both tests of incorporation and effective management are equally compelling under the separate entity view, it's evident there's no consensus as to whether to attribute these quasi-personal characteristics to corporation. And therefore, this comes back to our central argument that we say you should look through to a more substantial test of effective management. If we move to the benefit theory, we've already talked about this in terms of benefits supporting territorial taxes. And again, I won't labor the point, but given the conceptual difficulty in applying this theory, the faculty theory, rather, the benefit theory is also useful to justify corporate taxation. But as we've already said, the main problem associated with the theory to justify corporate tax is benefits can't be accurately measured and are therefore unlikely to correlate to the level of corporate profits. And indeed, just before leaving this one, some would argue that seeking to base liabilities on this basis is unjustifiable due to what economists would call positive externalities, which may be offset, such as the reduction in employment rates or increased intellectual capabilities or even entrepreneurial abilities. And as mentioned, none of the benefits or costs can be measured holistically by a reliable or empirical means. So the last one we've got there is regulation of managerial power, designed really to counter agency problems. And the conflict of interest inherent in the agency relationship is between corporate managers and shareholders and has been well documented in the literature. So I won't again labour on that. Safe to say that the regulatory functional view significantly narrows down the suite of possible corporate tests. And under this view, focus can be given to corporate managers. And the best candidate for determining corporate residence here would be the place of effective management, where, as we've said, strategic decisions and instructions are typically conceived. Alternatively, assuming greater separation and independence of the function from shareholders in publicly or widely held corporations, the listing place can be assigned as residence, as it's assumed to be the place where these agency problems arise and manifest themselves. So again, like the other theories we've gone through, this one suffers a conceptual deficiency in that the underlying presumption of agency problems may in fact be illusory. So for example, the interests of corporate managers are likely to be aligned if they're also shareholders, but the corporate tax would nevertheless be placed on the corporations with shareholding managers. So like other theories, there's no single residence test that arises from this view either, although it can be narrowed down to a fewer number than some of the other views above. But that quick tour is really designed just to illustrate that none of these gives us a single coherent basis upon which we can elicit a reliable test. So moving from there, as Nicole indicated earlier, and she summarized this really well, so I can probably move through this quite quickly. We then look at the model tax conventions to see whether we can distill any guiding golden thread from there. So as we all know, and we've got there in the first bullet point, 90% or so of treaties that exist globally are based on the OECD model or the UN model. And therefore it is instructive and important to consider these. Nicole also mentioned that since 2017, the OECD and UN no longer provide a standard to define corporate residence. And we spend some time in the paper critiquing the adverse consequences of that change, and I argue that it actually exacerbates, it makes worse the conflicts of international tax at a conceptual level. Now, the third point we've got there, we've gone through source-based taxation, so we spent a little bit of time looking at the work of the League of Nations after World War I and the doctrines that emanated from that, including economic allegiance, to assign taxation based on economic ties to a particular jurisdiction. Now, interestingly, of course, the doctrine of economic allegiance was, of course, built on the faculty principle. Regardless of whether a tax is payable by a natural or artificial person, the tax on a class of wealth ultimately falls, as we said earlier, on natural persons. Or in other words, domicile was attached to natural persons with consumption, referring to the enjoyment of wealth. Now, the OECD's model that has been updated over time retained the standard that corporate residence was determined by the place of effective management for over 5 decades. So it's a long period of time, and it was fairly well settled. And then, of course, as Nicole mentioned, in 2017, they became silent and moved away from that long-held position. And we argue that's caused more problems than it's actually solved. Now, in the last part of what I'm going to cover, so where are we at now really is what we're looking at here. So we've got Article 4 of the OECD model and the multilateral instrument, MLI, and both of them put forward the MAP, the mutual agreement procedure, as a way of doing it. Nicole also mentioned, just before coming back to the MAP, why did they withdraw this? They felt it was trying to overcome an issue of dual residence, and more specifically, they were concerned with tax losses with startup companies to be used as deductions more than once, so the double dip issue. Now, arguably, we contend that doesn't seem sufficient to warrant the removal of the tiebreaker rule, whereas the preceding tiebreaker rule could be interpreted to yield a consistent outcome despite different residence standards of contracting states. This new approach under the MAP seems to shift the issue of complexity to negotiation between signatory countries, thereby, in our view, exacerbating uncertainty to determining corporate residency and actually frustrating one of the key objects of double tax agreements, which of course are there to obviate or prevent double taxation. So Nicole mentioned the MAP, and I'm not going to go through this in detail, except to say it's well accepted that the MAP procedure is theoretically good, but it's difficult to access, it's costly, and it takes a lot of time. So, you know, we quote the example of 18 months, and when you're negotiating with some countries, this can go on for years. So if it's expected the conflict of dual residence would more likely arise by the absence of a unified standard and having to rely on this. So, you know, consider the simple case of one country determining residence on incorporation and another one using effective management, and both of them adopt several tests respectively to broaden it. So what do you do in the issue of a conflict there? You've got to go through the MAP. And then what if you're dealing with a developed country with a developing country? There's an inherent power imbalance there. So it's not an equal footing at the negotiating table, in our view, to have to rely on the MAP process. So this lack of uniformity may, in fact, in our view, lead to dual residence conflicts. And the MAP, in our view, wasn't intended for this purpose and is administratively onerous and subject to, as I said, other things, including power imbalances and time, cost, and difficulty of access. So where does that get us to? We get to a point of saying we don't think the current situation is sufficiently coherent. So with individuals, the OECD and UN models, you've got a hierarchy. So our argument is, why can't you have that in a corporate sense? Why can't, if there are diverse views on how we do this, why can't we have a hierarchy of considerations? And to take us through the rest of the paper and to further delve into that space, I'll hand over to my colleague, Christina. Thanks.
Thanks, Dale. You can hear me okay? Good.
Yep.
Since we've looked at the theories and different residence tests along with the historic development of the model tax conventions, now we can think about how the corporate tax residence rule can be formulated next. We think that the way to meaningfully attribute corporate residence is by making reference to the term enterprise, that is, carrying on business. Although there is no single tax policy rationale for taxing corporations to which we can make reference for defining corporate residence, arguably, the place of effective management is broad enough to capture profits that might have not been taxed in source taxation. So essentially, this approach accords with a widely accepted notion that corporations must be taxed on a source basis, where the residence concept will be used as an instrument to operating source-based taxation. So here we focus on 3 aspects to further support the place of effective management test as a tiebreaker rule. The first, the residence test must be designed for all corporate structures, whether public or private. The place of effective management test has a universal applicability regardless of the firm size or type. When we look at the source principles, people continue struggling with what the real business is, where assets are located, where activity is undertaken, where risks are borne, or even the question of where value is generated. So this struggle is more profound in dealing with the digital economy. In fact, Fogel, renowned tax academic in international tax, noted that source is not self-defining. When we approach the tiebreaker rule with a focus on avoiding stateless income, the rule would be a fallback provision in source-based taxation. In this conceptual framework, we can say that the effective management essentially encompasses an enterprise in a holistic manner, in a sense that all activities and everything else involved in a corporate affairs, assets, risks, and strategies, etc., are bound by the controlling mind that we call effective management. This test will be based on substance, not form, to retain flexibility regardless how the future economy evolves. Now, this leads to the second, the justification of using the place of effective management as a tiebreaker rule from the perspective of adaptive interpretation. The residence rule should be non-sensitive to time or changing commercial practices. A principal basis of corporate residence should assist in preventing artificial or contrived arrangement, and such arrangement should not change ultimate tax outcomes. In the landmark decision, De Beers, the case sought to find the place where the real business was carried on. In the past, Australian cases, particularly the Malayan shipping case, courts try to find for the residence test that the place where the real business was carried on is where the controlling mind resided. In applying this principle, the court in Bywater, which is a very recent case, which considered both the central management and control test and effective management, struck down tax avoidance structure. In this case, residence was determined based on the place of a real controller, who was the Sydney-based accountant, but he was not a shareholder or even a director. So it appears that the place of effective management test has the ability to counter artificiality and contrivance and operates flexibly to ascertain the locus of control. Third, corporate inversion and electivity should be minimized in setting corporate tax residence. These days, forming a legal entity is relatively easy and costless. And the concerns for corporate inversions under the incorporation test have been well versed. This, however, significantly impedes tax neutrality, one of the very important income tax design principles, that is, tax should not change economic decisions, and if any distortions of economic decisions should be minimized as much as possible. Using the incorporation test as a tiebreaker rule, knowing that it creates corporate inversions, is unjustifiable. In the same vein, determination of corporate tax residence based on the shareholding structure, for example, 50% voting power held by resident shareholders without tracing the beneficial ownership of the company is also can be also rejected. Next slide, please. Now, in most cases, it wouldn't be necessary to provide multiple tests to define corporate tax residence, but there may be times where effective management may not break the tie of dual residence. For example, some corporations may genuinely have 2 or more strategic homes. An example can be found in De Beers, although the court just focused on the questioning whether the company resided in the UK, setting aside whether the company also resided outside the UK in that case. Dual residence was properly recognised as early as 1925 The precedent was Swedish Central Railway Co Limited and Thomson, the UK case. Now, we acknowledge that giving multiple tests of equal weight is likely to cause unnecessary conflict, but we also find an alternative approach to provide a hierarchical order of rules, as Nicole mentioned, as used in the individual residence test in treaties. So some other tests following the place of effective management test may be introduced as part of the tiebreaker rule. Then what kind of rules can be listed? We looked at the literature, the paper written by the US author Desai. He provided 3 functional headquarters under the fragmented business model of multiple enterprises in the 21st century. These 3 headquarters are, number 1, the finance center, number 2, the legal center, number 3, the managerial center. Translating them to the context of corporate residence, they can be recast as number 1, the place of security listing for the finance center, number 2, the place of incorporation for the legal center, and number 3, the place of executive managers for the managerial center, in addition to effective management. The conundrum about the second order test is that there is no discernible way of ranking the place of security listing and the place of managerial talent for publicly listed companies. Also, the place of managerial talent may be difficult to ascertain. Without further assistance, both may be given equal importance as the second order. The place of incorporation, on the other hand, can be the third order in the tiebreaker rule to operate as a last resort. Considering the potential irrelevance of security listing and the difficulty security listing in the case of private companies and the difficulty in ascertaining the place of managerial talent in practice, incorporation test may be given considerable weight despite its third order in the tiebreaker rule, and we intend that this operation is okay. Next slide, please. In concluding, we note that the OECD continues its effort to provide a coherent and durable framework for establishing international tax norms under the BEPS project. As part of the BEPS project to this date, we observe that the corporate residence tiebreaker rule, hinging on the effective management, has been withdrawn in the model treaty, with the UN model following suit. The OECD provided that the reason for the withdrawal was to address stateless income. However, having no standard is likely to increase the stateless income issues further and arguably creates additional scope for power imbalances. Also, this stunt seems to be against the trend, even that advocated by the OECD under the BEPS project to coordinate international taxation. We found that defining corporate tax residence is notoriously difficult in the absence of a convincing normative value suggested for corporate income taxation. Having acknowledged this, we examined whether the removal of the tiebreaker was appropriate. We looked at the historic merit of the effective management test and conceptual underpinnings of the test, as well as some tax practices. In our view, the tiebreaker for corporate tax residence based on the place of effective management should be restored and supplemented by a second order tiebreaker rule. We suggest where there is a tax dispute as to dual residence between countries, the second order tiebreaker be based first on the place of security listing, then managerial talent, and lastly, incorporation. I think that's the last slide. Thank you very much for listening to our presentation.
Brilliant. Okay, well, I'll stop sharing the screen so we can see each other. And a minor miracle that I managed to do that. But over to you. So, yeah, thank you for the opportunity.
Thank you, everyone. Thank you for this amazing lecture on the OF test, why it should be brought back as a tiebreaker rule. It's really interesting to see actually that the major issue with the poem was also surrounding the domestic application of how the various guidelines are there in different jurisdictions to determine what the poem would be, where the place of effective management of a corporation would be. Like, for example, in India, we have three strict conditions which should be satisfied for a lenient application of a place of effective management test. And if either one of those conditions are not satisfied, then a very strict scrutiny is done by the revenue department to determine where the place of effective management would be. And this actually brings me to an interesting question, which was there before 2017, before the changes made in the OECD Model Tax Convention, was that there was liable to tax issue, which was there with the poem attached, that there was the domestic issue that because of place of effective management, the corporation should be taxed in those domestic jurisdictions domestically at greater level, and that got a whole set of different disputes and issues altogether. But I think one of the reasons was also to do away with poem in 2017 model was also this. But don't you think that if we introduce the poem again in the tiebreaker rules, OECD or any other international organization should also try to bring an autonomous definition in the treaty itself of what would constitute a place of effective management, which would then override the domestic guidelines, domestic provisions which are there for determination of poem. Because if there are domestic contradictory guidelines, then we are again at square one, I would say.
Yep.
So
No,
I
thanks.
would really like to hear your thoughts on it.
Yeah, no. It's a really good point you raise, and I think there's two aspects that I will address, and Christina, you might want to add after that. So one is obviously a definitional one. What does place of effective management mean? And we know there are differences in jurisdictions and courts and so on. So that's not a universally held view. And I think you're quite right. As a internationally coordinating body like the OECD, one of their functions surely is to help us by distilling common elements of what they should have. I mean, bearing in mind they can't mandate everything, but they're very persuasive. So if they say, it should show these things, then that would be helpful, because otherwise you end up with this hodgepodge of different definitions. So we have this just in Australia. I'll give you a state example. We have payroll tax, which is a state tax. And the definition of wages, which you think would be obvious, differs state to state. So you end up with this incoherent system, and no states want to federate and come up with a umbrella definition. So that is an issue. And I think you're right. OECD or even a bigger organization could look at a common definition, which would certainly help. I mean, tying in the second part of my response to what someone's put in the chat is, because of this difference, we could end up with different views of where the place of effective management is. But I think that's the beauty of the model we're putting forward in terms of hierarchy. So let's say you don't get a clear view from tier 1, you might then come to tier 2, which supplement it. But currently having nothing is, to take my colleague Dr. Allen said earlier, that's the worst position, because then it's a free-for-all, as we would characterize it in Australia. Everyone does what they think, and then we know that jurisdictions act with political and revenue imperatives rather than ones that are based on economic or legal principles. But Christina, did you want to add anything to that? I think you're on mute, Christina. I can't hear you.
Not any content in big deal, but just one thing to talk about. The change was influenced by the US, because the US started looking at coming into some agreement under the BEPS project, and the US has traditionally used the incorporation test. So having a big economy using the incorporation test, what is really the point of having the effective management test, and it was kind of some political influence there. But what we've essentially said was that just by having no test in the case of dual residence, how is that going to actually help the situation with the stateless income better? Are we not making the situation worse? In terms of different applications of residence rule, even though many countries may use the central management and control as their principal basis for ascertaining corporate residence, still the jurisdictional interpretation will be different country by country. And but in the end of the day, we acknowledge the differences in law, and we just want to find a solution where we can coordinate some standards better or more effectively. So what we are comparing to having no standard at all is our suggestion is basically to have some standards, actually, in fact, multiple standards in hierarchical order, where we instead of going to the MAP process, which can take forever. You might have looked at the statistics of the MAP process. It's massive, and there are still there's some cases which are ongoing after 7-10 years. So is there really an effective way of negotiating different tax disputes between jurisdictions? Let me just quickly... go on, Dale.
Yeah, no, I was just going to add, if you look at it from a tax policy principle point of view, so when we are thinking of good tax systems, we look at simplicity, certainty, equity, neutrality, and efficiency. So again, having nothing, how does that help with simplicity? And having nothing, how does that help with certainty? So we would argue it violates at least two of the tax policy principles. So it just doesn't help staying silent on an issue like this.
Yeah, and also just because the comment in the comment economic nexus was mentioned, we didn't really explain in detail, but when you have a look at the League of Nations, it is looking at economic nexus, and there are many economists and in fact tax scholars as well who just argue that the corporation should be taxed on economic basis, and by doing so we will be able to capture everything. Essentially, we should be able to capture that. As a matter of fact, we don't, quite often in the digital economy context, we don't know where the source should be. And now we have a trouble with what are we going to do with the remainder. So I think this is a quite interesting area. I mean, we can argue that let's get rid of the corporate residence concept altogether and just go by source taxation. Yes, we can do that, but then we'll probably need to change a lot of laws in terms of dividends and royalties and PE concepts and everything. In addition, we've got to see how the inclusive framework, the current projects will be developing to capture any remainder more effectively, so that the significance of corporate residence may be reduced naturally. If we don't have that in place as of now, then if we want to stick to the fact that we will use the residence concept in corporate income taxation, then it is better that we have some kind of standard.
Thank you for the question. It was a really good one.
Thank you for your views. It's really interesting topic. So yeah, thank you for this. Thank you for this intriguing lecture. And with this, I would actually call upon our director of CCIT, Kriti, Professor Kriti, to.
Thank you, Ritesh.
Thank you.
Thank you so much. On behalf of CCIT, we'd really like to thank you all for taking out time and taking us through this interesting presentation. It was very insightful for us to go through these rules. Thank you so much.
Great, wonderful. Thank you again for the opportunity. We really enjoyed it and enjoyed interacting with your colleagues on the other side of the world. So we hope we stay in touch and maybe we can do some research together as well.
Absolutely. Looking forward to interacting again. Thank you so much.
Thank you so
Okay.
much.
Thank you so much.
Bye for now. Bye. Bye.
Bye.